If you're worried at all about content that is posted by others about you with respect to the advertising rules, you really shouldn't, because they just flat out can't apply to you. Now, there's a couple of questions that I'll get to now. There's others I'll get to at the end, I hope, but this does relate specifically to testimonials. If you know a testimonial is inaccurate, can you be responsible for it if you see it? I would say the good practice would be to try to fix it. I'm not sure exactly how it would be inaccurate. On the positive side, you can certainly, if you know who wrote it, try to get it changed. But I mean, technically, under CDA 230, you're not going to be responsible for it if you didn't post it. And then the question is, if you post testimonials on your website that are actual client quotes, but the client remains anonymous, once you're posting them on your site, you're getting far closer to testimonial advertising. I'm talking about information that is technically posted by others. If you were to host a forum on your site where clients could go in and leave feedback, that would again be subject to CDA 230, and you wouldn't be responsible for it. But if you're sort of taking control of it and massaging those quotes and testimonials the way that testimonial advertising is typically done, then you should expect that would be something that the bar would look at, and you'd want to make sure you were in compliance with your state's rules. Okay, so let's move on to the next area, which is client solicitation. Now, this is I mentioned before how one area of attorney advertising regulation that has always been upheld by when it's been challenged in the courts is restrictions on client solicitation. And the typical restriction on client solicitation is that you can't engage in telephonic, in-person, or real-time electronic solicitation. The idea being that your powers of persuasion as an attorney against someone who may not be prepared to choose an attorney, it's not going to lead to a good outcome. And that's why you'll see differences in solicitation rules with respect to stuff that's happening in real time and in person, as opposed to stuff that happens via the mail or via passive advertising channels. And so the only decisions I've seen in any state that have had to do with electronic stuff have basically looked at email and decided that email is not real-time electronic. It's more analogous to snail mail, where people have time to reflect. There's not an expectation of immediate response. Nobody knows what the case would be with Twitter, for example. I think Twitter is probably the better argument is that Twitter is closer to email than it is to, say, a telephone call. But again, it's uncertain, and I know that some attorneys use Twitter. It's a great sort of temporal/geographic search engine, so you could